court is holding this hearing on an emergency basis. I'm actually out of town, but I wanted to give the parties the opportunity to have their emergency hearing held. So the court is doing this via Zoom and broadcasting it to YouTube for public access.
Drake McCusker, attorney for the department, and Judge, we have no objection to the hearing being held via Zoom and broadcast.
David Nelson, CASA volunteer. I have no objection to the committee.
Amy Harding, Hill Country CASA supervisor. No objections to the hearing be held by Zoom.
Celia Howard on behalf of the child, no objection.
Kurt Bradkin, attorney for Roland Reyes, no objection, attending by Zoom.
Jennifer Harris, attorney for respondent father, Mr. Moselle. Due to his incarceration, it takes quite a bit of time for me to be able to get a hold of him. So I would announce not ready.
Gosh, permanency supervisor with Belong.
Alejandra Certuche, permanency specialist for Belong.
Tanya Spano, CPI investigator.
Ms. Pearson, could you unmute and announce, please?
Misty Pearson, mother of Christian.
Ms. Pearson, have you had any contact with Ms. Acosta in the last few days?
No, sir, I have not.
Okay. All right. Any word, Ms. Hellroan or Ms. Greenlee?
No, it's still ringing. I just keep getting voicemail.
Okay. Mr. McCusker, could you, just for the sake of the record, screen share the notice that you sent out, please?
Is a screenshot of my my email showing the order setting hearing on the motion that was filed by my legal assistant, Jamie Martinez, on June 26, 2023 at 4:23 p.m. If I scroll down to the service contacts, Ms. Acosta's email, Acosta is included on the service contacts.
Okay. Thank you. She just entered the waiting room, so got her here now.
Good morning, Judge. I apologize for being late. For some reason, this did not make its way on the right date on my calendar.
Okay. Thank you. If you would please announce for the record.
Irene Acosta, I represent the mother, Misty Pearson.
Ms. Acosta, during the announcements, I made sure the parties knew that this is an emergency hearing. I'm actually out of town, but I wanted to make sure that the emergency hearing could take place. So I am broadcasting this by Zoom only. I'm not in the courthouse, and the hearing is being broadcast on YouTube. I gave the parties the opportunity to voice any objections they may have. So far, there have been no objections, but I want to give you the same opportunity.
Judge, I think my objection would be that you had previously stated in a prior hearing that you weren't going to entertain moving the child. And also, I think I was given notice on, I'll check when I was given notice.
Well, Mr. McCusker, I can save you the time. He screen shared the notice that went out on Monday. It was the 26th.
Okay, and I would agree with that. I'm not going to object to notice. I think my only objection would be, one, I don't think this is a normal date that Crow County hearings are held. The mother is opposed to the motion, and I would say it's not an emergency. But I know the ad litem and the department are disagreeing with that statement.
Okay. I'm going to overrule your objections, and we will proceed with the hearing this morning. I know the court did previously state that moving the child was not something we were going to do at that time. However, my understanding is that new evidence has come into light when we give the opportunity to the parties to introduce that evidence. I also had Ms. Greenlee make sure the parties were aware that I've got an hour this morning. Like I said, I'm out of town, and set this at the last minute so that we could entertain any emergency that may take place. So I need everybody to be concise and expedient with your questioning, please. So with that, any other housekeeping issues we need to take up before we begin? Okay, then Mr. McCaskill, you may call your first witness or open, whichever you prefer.
Judge, just for the sake of time, I'll just call my first witness.
Okay, thank you.
And that Mr. Tucci, Judge.
All right, Mr. Tucci has been sworn. You may
How are you
proceed.
currently employed?
Well, I belong as a permanency specialist.
Okay. And are you the permanency specialist that's assigned to this case?
Yes,
Okay. And how long have you been the permanency specialist for this case?
since the beginning of March.
Okay. The court previously held a hearing on June 7th, 2023. Is that correct?
Yes,
And during that hearing, did the court order the department and the parties to hold a staffing to discuss issues that were covered during the course of that hearing?
yes.
Okay. And when did that staffing occur?
On June 12th,
Okay. And did you attend that staffing?
I did.
Okay. And did Ms. Pearson attend that staffing?
Yes,
Okay. During the course of that staffing, did you all develop a plan moving forward?
yes, it's a safety plan.
Okay. And what did that safety plan address?
The concerns that we had for the individuals coming into the home, assuring that Ms. Pearson would keep up with Christian's attendance at YMCA. And we were notified by Ms. Pearson that day that that Christian was discharged from MHTD. So she was instructed to sign him up for K-Star, for counseling at K-Star.
Okay. So let's just kind of go through each one of those one at a time. Let's start with the MHDD services. Were you able to follow up with MHDD to confirm whether or not Christian had actually been discharged by them?
Yes, I was. And the information provided by Ms. Pearson was inaccurate, as he was actually requested to be discharged from MHDD by Ms.
Okay. So it's your testimony that rather than MHDD discharging Christian, it was Ms. Pearson that withdrew him from their services.
No, I'm going to object as to calls for speculation. I'm also going to object as to hearsay.
Response.
Judge, that question was a clarifying question, just to clarify her testimony that she already provided.
Go ahead.
Mr. Tucci, can you answer that question, please?
Yes, I said correct.
Okay. The
Objections
services.
overruled.
Thank you, Judge. The services that Christian was to receive from MHCD included an IDD evaluation. Is that correct?
Yes, that's correct. And that was not done.
Okay. And that IDD evaluation was actually previously ordered in this case. Is that correct?
Yes.
Okay. Are you aware of whether or not K-Star is able to conduct that IDD evaluation for Christian?
I'm not extremely sure, but I can double check.
Okay. So you said at the meeting, you guys also covered Ms. Pearson enrolling Christian in K-Star. Has she done that?
She was scheduled on 6/15. She had the intake for Christian. And then on 6/19, she was scheduled to go back, but she canceled that appointment prior to, and she has not rescheduled, and she did not state why she was canceling it.
Okay. Did she attend the intake appointment on 6/15?
Yes.
Okay. So it was the second appointment then on 6/19 that was not complied with?
Correct.
Okay. Are you aware of any other or any rescheduling of those appointments with K-Star at this time?
There has not been any appointments rescheduled with K-Star, no.
Okay. And then finally, you said that you also discussed individuals who were around Christian during that staffing on 6/12. Is that correct?
That's correct.
Okay. And was there any particular individual the parties were concerned about that was being around Christian?
Yes, the individual was Dan Shell Cooper.
Okay. Why are the parties concerned about Mr. Cooper?
Mr. Cooper has extensive CPS history involving physical abuse, RTVs, and he has extensive criminal history as well that involve assault, family violence, possession, delivery of drugs.
Okay. And Have you asked Ms. Pearson about her association with Mr. Cooper?
Yes, she denies the contact with Mr. Cooper, and she stated he was just an associate.
Okay. Is this the first time that Mr. Cooper's made an appearance in this case?
No, I believe it was at the start of this case. There were allegations that she was with him when the children were left unsupervised.
And were those her contact with Mr. Cooper concerning at that time as well?
Yes.
Since the hearing on the 7th and the staffing on the 12th, has Christian been regularly attending the YMCA program?
No, he has not.
And do you have any knowledge of why Christian has not been attending the YMCA program?
Ms. Pearson has been able to provide me with some doctor's notes, but the majority of the reason why he's been absent is because he's been sick.
Okay. Do you have any concerns for Christian whenever he has been attending YMCA?
Just the concerns that he's not engaged with staff and he's sleeping and he's always observed to be tired.
Okay. With regard to Ms. Pearson, is she currently engaged in complying with her MHDD services?
No.
Okay. And what sort of services is she supposed to be receiving from MHDD?
She's supposed to be getting skills training, monthly visits and case management and support services through therapists there at MHDD.
Okay. And when did she stop attending those services?
I believe she has not attended since sometime in May. I don't have the specific date, but she's canceled and she's no-showed.
Okay. Is Ms. Pearson currently engaged in her individual counseling services?
Yes, she has missed one appointment.
Okay. And who is she currently seeing for individual counseling?
Lucia Cobb.
Okay. And when did she start seeing Ms. Cobb?
On May 24th, she was referred to Lucia Cobb. And I believe on June 6th is when she attended with Lucia Cobb.
Okay. So has she attended any sessions with Ms. Cobb since June 6th?
Yes, she has.
Okay. And when did she attend that session?
So I have her information right here. She completed her intake between May 26th and May 30th. And then she had 2 sessions on June 13th and June 22nd, and she missed on June 6th.
Okay. Prior to Ms. Cobb, who was Ms. Pearson seeing for counseling?
Joni Chavez.
Okay. And was she, why is she no longer seeing Ms. Chavez?
She was dropped by Ms. Chavez due to
Okay.
her attendance. She did not show.
And then
I have a clarifying question, please. I thought I heard you testify that she attended with Lucia Cobb on June 6th. And then I think I might have just heard you testify that she missed on June 6th. And maybe I misheard it, but.
No, I misspoke. I went back on my notes.
Okay, so she didn't go on June 6th,
She did not go on June 6th.
but she did go on June 13th and June 22nd?
Yes.
Okay, thank you.
Mhm.
prior to Ms. Chavez Martel, who was Ms. Pearson seeing for counseling?
Optimal counseling.
And why is Ms. Pearson no longer with optimal counseling?
She was dropped due to her attendance.
Okay. And we recently extended this case, correct?
Yes.
And so we're well into this case at this point. Ms. Pearson's on her 3rd counselor.
Yes.
And Ms. Pearson's only had 2 sessions with this 3rd counselor. Is that correct?
Yes.
Is that concerning for you?
Yes.
Okay. Why is that concerning?
I believe Ms. Pearson has mental health issues that need to be addressed, and they are not being properly addressed because she is not compliant with the services that we are providing for her.
And do you think that those services are necessary for Ms. Pearson to be able to provide Christian with a safe and stable home?
Yes, I do.
Have you had any recent interactions with Ms. Pearson?
Yes, I have.
Have you had any concerns based off those interactions?
Yes.
And what are those concerns?
She has become, I want to say, aggressive with me. She's cussed me out a couple times. She cussed out my supervisor as well. And she became inappropriate to me in front of Christian this last visit that I did this week.
Okay, and when was that visit?
That was on Tuesday.
Okay, and when you say that she was inappropriate towards you and towards Christian, can you please explain what happened?
She was raising her voice and she turned to yell at Christian if he wanted to go to a foster home.
And how did you address that with Ms. Pearson?
I repeated myself by telling her that it was an inappropriate time to have that conversation because Christian was present and he was uncomfortable and I was uncomfortable.
And after you addressed that with Ms. Pearson, did she stop making those sorts of comments?
Well, while I was making those statements, I also redirected her and asked her to reach out to her attorney, and then she closed the door on me.
Okay. Do you think that Ms. Pearson is currently meeting all of Christian's physical and emotional needs?
No.
Why not?
Judging by the way she was behaving herself with me present, and I could visibly see Christian becoming increasingly uncomfortable, I don't believe he felt safe in that environment. And Christian is not attending the proper services to make sure that the issues that he's had are being addressed.
Do you think that Ms. Pearson is being honest with the department during the course of this case?
No.
Why not?
Because I've had providers tell me the opposite.
Pass the witness, Judge.
Mr. Costa.
Thank you, Judge. Ms. Ertuche, with regard to Ms. Pearson's counseling, what is your understanding of why she missed with Joni Chavez?
She was not feeling well.
Were there any other reasons that were provided?
No.
Do you not recall having a conversation with me and with Ms. Pearson wherein you were informed the reason was Ms. Chavez was requiring in-person visits and Ms. Pearson had Christian during those visits?
I'm sorry, I thought you were asking about Lucia Cobb.
No, ma'am, I said Joni Chavez.
Okay, Ms. Chavez. Yes, I do remember that conversation.
So Ms. Pearson's appointments with Ms. Chavez were during times that she had Christian, correct?
Yes.
Okay, and Christian is not allowed to attend the visits, the therapy visits, is he?
No, but the times that...
Excuse me, and at that time, the department had not approved anyone to watch Christian, had they?
Just YMCA.
But he was not involved, he was not enrolled in YMCA at that time, is that correct?
He was.
When she was seeing Joni Chavez?
When we just re-referred her, or the first time? Because she's seen Joni Chavez twice throughout this case.
I'm talking about the time closest to this hearing.
No, we had Christian in YMCA.
When has Christian been enrolled in YMCA? What are the dates?
I'm going to have to go back and check on that.
If you don't know the exact dates, how can you be sure that he was enrolled in YMCA during the times that she was supposed to be going to have visits with Joni Chavez?
On March 8th, YMCA was paid for the duration of the school year, and he was to remain there until 5:30 p.m. on school days. And then on May, he's been attending since then. We've had it paid for since then.
Okay. Has he been sick during that time at all, to your knowledge?
Yes.
Okay. So if he's sick, he cannot attend YMCA, can he?
No.
He was staying with mom. Is that correct?
Yes.
Okay. And if Christian is sick and mom has an appointment that he's not allowed to attend, can mom go to that appointment?
No.
Okay. You said that on June 6th, mom did not go to counseling. Is that correct?
With Lucia Cobb, yes.
Okay, do you know why?
She was sick.
Okay, so mom had a valid reason as to why she didn't attend that counseling session. Is that correct?
She no-showed, but Miss Cobb is the one that asked Miss Pearson the following day why she missed. And that's when Miss Pearson said that she didn't go because she was sick.
Okay, with regard to Mr. Cooper, is it true that mom has told you that he has not been around Christian, correct?
Mom has told me that.
Okay. And the only stipulation that the department and Belong have communicated to mom is that individuals not cleared by the department are not allowed around Christian. Is that correct? Let me rephrase that. If an individual has not been cleared by the department, they're not allowed around Christian, correct?
That's correct.
Okay. But mom, there's nothing barring mom from going around them on her own, correct?
Yes, that's correct.
Okay. So as long as this individual has not been around Christian, there should be no issue, correct?
As long as you're not around Christian, yes.
Okay. And as far as mom has told you, he has not been around Christian. Is that correct?
As far as mom has told me, he has not been around either of them.
Okay. So scratch that. When you went to go speak with Ms. Pearson, most recently, when you claimed she was being inappropriate with you, what did you start talking to her about?
I told her I was there to do my weekly unannounced visit. And then I notified her that we were going to be having court this Friday, and I sent her the link. And right then and there is when she said, "So what is y'all's plan? Are you trying to remove him?" And I said, "We just have concerns that we are going to be bringing up in court. And that is the reason why we are having this court hearing. If you have questions, you can ask your attorney."
So you brought up the topic of removing Christian with Ms. Pearson when you went to go visit her?
No, I said we had concerns and it was going to be discussed in this court hearing, and that I was not at liberty to say anything that would come of the court hearing.
Okay, but just to clarify, Ms. Pearson didn't start the conversation off discussing court this Friday. Is that correct? You started the conversation off regarding having court this Friday. Is that true?
To send her the court link so that she wouldn't miss.
So why was it necessary to bring up the topic of court instead of just sending her the link?
Because she's my client, and I would assume that it would be permissible for me to just inform her of a court hearing coming up to ensure she attends. And if she had appropriate questions like what time, I would be able to answer that in her face so that I could be able to say that I was able to notify her in person of the court hearing to make sure that she attends.
Rather than discussing it via text or email outside of the presence of Christian.
If I was in person with Miss Pearson, I've been able to inform her of things like that before.
Okay, I'm going to ask a different question. Do you think it would have been prudent not to bring up an adversary hearing in front of Christian?
I'm going to say no because I've discussed this with clients multiple times just to inform them of a court hearing.
Do you think it's in the best interest of a child to be speaking about a removal hearing in front of them?
I didn't speak of a removal hearing in front of them.
That's not the question I asked. Judge, I'm going to object this to non-responsive.
Also sustain that objection, but then we need to wrap this line of questioning up.
I'm moving on, Judge. You can, with regard to Christian and the request to get an IDD, is it a fair statement to say that there was confusion about what was requested and when?
No.
Why wouldn't that be a fair statement?
MHDD was in charge of getting those assessments done, and Ms. Pearson was aware of that. following mediation when it was discussed at the court hearing.
When was the most recent time that the IDD was discussed?
At that court hearing.
Was it also discussed in the most recent staffing?
I believe so.
Okay, and do you recall Ms. Pearson explaining that she had some confusion about the request?
No, I just recall Ms. Pearson stating that he was discharged from MHDD, and then I was to follow up with MHDD.
Ms. Artucci, when were those most recent interactions that you had with Ms. Pearson? What day did they occur?
This Tuesday.
Would that be Tuesday, the 27th of June?
Tuesday the 27th.
So what actions in particular are you basing this removal off of?
What, I'm sorry?
So we had a staffing, we had a new safety plan that was made, correct? So what items on the safety plan are you saying that Ms. Pearson violated?
The Dan Shell Cooper around Christian. And she didn't follow up with K-Star because he did not attend that appointment, and she canceled it and didn't reschedule it.
And that's the appointment on 6/15?
Yeah, she did the intake, but the appointment that followed after that, she canceled it.
Okay, and
rescheduled.
okay, so the appointment that was canceled, were she or Christian sick on that day?
No.
What reasons were given for the missed appointment?
There were no reasons.
Okay, I'll pass the witness, Judge.
Ms. Harris, I know you announced not ready, and I don't believe that because your client's incarcerated, there's any prejudice against the department. If I grant you're not ready, as far as Mr. Mosel goes, do you have any questions for Ms. Zartucci?
No, Your Honor.
Okay, and just for the record's sake, I do understand Ms. Harris has had difficulty getting in touch with Mr. Mosel in the past, and so as to Mr. Mosel, I'll grant her not ready, but we are obviously proceeding as to the mother. Mr. Rudkin, any questions?
No, Your Honor.
Ms. Halrung?
And for purposes of time, I have one. Ms. Zartucci, when the issue of MHDD came up in his counseling, isn't it true that not only did Ms. Pearson not say that he was discharged, but that he was discharged because he did not need counseling?
That's true.
Nothing further, Your Honor.
Thank you, Ms. Halrung. All right. Do you have any redirect, Mr. McKeska?
No, Judge, for time purposes, I'll move on.
Okay. All right. Next witness.
Yes, Judge, I'd like to call Ms. Harding. Are you the case supervisor for Christian's case?
Yes, I am and have been since the beginning.
Okay. Do you believe that Ms. Pearson is meeting Christian's physical and emotional needs right now?
I do not.
And can you explain why?
I can. Because through my conversations with Christian, he has asked me questions about specific people that he should not be around. He has specifically asked me who Dan Shell.
I'm going to object as to hearsay if she's testifying as to something that the child said.
And Judge, if you were to turn to section 104.006 in the Texas Family Code, hearsay statements of a child abuse victim. The code specifically says in a suit affecting the parent-child relationship, a statement made by a child 12 years of age or younger that describes alleged abuse against the child without regard to whether the statement is otherwise inadmissible as hearsay is admissible as evidence if in a hearing conducted outside the presence of the jury, the court finds the time, content, and circumstances of the statement provide sufficient indications of the statement's reliability and the child testifies or is available to testify at the proceeding in court or in any other manner provided by law, or the court determines that the use of the statement in lieu of the child's testimony is necessary to protect the welfare of the child. If you'd like, Judge, I can take Ms. Harding on voir dire to establish those grounds, to allow her to, if the court were to allow for her to testify as to statement or Christian statements. But I do believe the statements that he's made to Ms. Harding and to other individuals would qualify under this provision.
I agree. I think that this is exactly a situation why 104-006 exists, and the court will make a finding that the child is 12 years of age or younger and has described alleged abuse, and the court finds that there's sufficient indications of the statement's reliability, and that the court will use the statement in lieu of the child's testimony as the court finds it's necessary to protect the welfare of the child. So you may continue.
Thank you, Judge.
Objection is overruled.
So, Ms. Harding, when did you meet with Christian?
I met with Christian a couple of times. I went to the YMCA on Friday, June 9th, and found that he was not in attendance. So I went and was able to see him while he was with Miss Pearson at the Flagstaff Inn. He was sleeping at the time, so I could not talk to him. And I decided that I would go back and see him the following week. So on Tuesday, the 13th of June, about 9:15 in the morning, I went and saw him on the playground at the YMCA.
Okay. And whenever you saw him on the 13th, is that whenever Christian made statements regarding Mr. Cooper?
He did.
Okay. And what outcries did Christian make with regard to Mr. Cooper?
He asked me if I could talk to his mom about Dan Shell. He didn't know his last name, but about Dan Shell. He asked me who Dan Shell was. And when I asked him why, he told me that Dan Shell cusses him a lot, and that on one occasion, at least, he grabbed him by the arm and hurt him very much.
Okay. Did Christian provide any additional details regarding his interaction with Dan Shell?
He told me that they saw him when Dan Shell grabbed his arm, they were living at the Flagstaff. And that was a relatively new housing situation for Miss Pearson and Christian. So I knew it happened recently. I asked Christian if they had seen Dan Shell other places than where they were living, and he informed me that he had been to Dan Shell's house. He also informed me that Dan Shell did not hurt mommy like he hurt him, and he did not talk to mom like he talked to him, but that he had been around Dan Shell, and gave me the impression that it was on definitely more than one occasion.
Did Christian give any indication whether or not Miss Pearson was present for those interactions?
Yes, he said that mom was always there.
And did Christian make any sort of statements regarding Miss Pearson acting in a protective manner to stop Dan Shell from what he was doing?
No, I asked Christian if mommy stopped him, and he said, no, mommy didn't do anything. And that's why he wanted me to talk to mommy about Dan Shell.
Have you had the opportunity to speak to Miss Pearson about Mr. Cooper?
No, I have not.
Okay. Do you have any additional concerns for Christian?
I do.
What are those additional concerns?
When Christian was living with previous caregivers, he frequented the CASA office on a weekly basis. He came in at least once or twice a week, and he was happy. He was very extroverted in sharing activities of his day, talking about what he did in class with his teacher, who he calls Miss Birdie, because he can't really say her last name. And he had lots of energy, looking for candy, wanting to get on YouTube, wanting to sing songs, lots of energy. And he did not have that when I saw him. He looked tired. He looked sad. I visited with him for almost 45 minutes before he shared with me he wanted me to talk to mom about Dan Shell. I think he was very reluctant to share because he loves his mom and he doesn't want to get anybody in trouble. but I am concerned about him. I'm concerned about his emotional well-being, not being in therapy services, not having someone regularly monitoring his medications, not assessing him for things that he might need down the road when we are not involved. I'm concerned about all of those things.
Do you think that it'd be in Christian's best interest for the court to authorize the change in placement that's being requested today?
I do think it would be in his best interest to make sure that all of his physical and emotional needs are being met consistently. Ms. Pearson is inconsistent in taking care of those things. I'm also concerned with how frequently Christian has been sick over the summer. And I want to make sure that we have him in a stable living environment where he can have all of his needs met and he can feel safe asking for things. I think he's confused, and I don't think he knows who to trust right now. And I think he's very guarded.
Pass the instruction.
Ms. Harding, when you were speaking with Christian about Mr. Danshell, did he give a time frame as to when Mr. Danshell was around him?
The only way that I could establish a time frame was by asking him where they were living. Christian couldn't give me additional timeframes.
Okay. And in speaking with Christian previously, or any time that you've had interactions with him, is he accurate with regard to where he is when things occur and place and time, I guess is my question. When you're speaking to him, is he able to formulate accurate relationships with space, time, and where he is?
Sometimes.
Okay. And so if he's not always accurate about when and where things occur, are you absolutely certain that he was around Danshell recently?
I am, because I say sometimes because you have to spend time with Christian to know how to engage with him and ask him questions. And so I could ask him questions like, did it happen before or after Christmas? Or who were you living with? Or what school were you going to? Or were you living with this sister and not this other sister? And so he can give you time and location and information if you give him some parameters to help you establish that. And so he was able to tell me that they were living at the Flagstaff. And it's my understanding that the only time they've been living at the Flagstaff has been recently.
Okay, thank you.
Mm-hmm.
And I think you testified to this already, and I apologize if I'm repeating a question, but did you discuss any of this with Ms. Pearson?
I have not had an opportunity to do so.
Okay, thank you. I'll pass the witness, Judge.
Just one. Ms. Harding, do you think it's logical that Christian would have asked you to talk to mom about something that happened long ago or not recently?
No, I don't think Christian would have asked me to talk to mom about things that happened a long time ago. I feel like because of the information he shared with me that it was a recent occurrence and it disturbed him greatly.
Nothing further, Your Honor.
Mr. McKeska?
Nothing further, Judge.
For this witness, or do you rest?
Judge, just for time's sakes, I know we're running slow, so I rest.
Well, if you have anything else that you feel like absolutely need to hear.
Judge, I believe Ms. Spano's testimony would pretty much mirror Ms. Harding's testimony. And so I don't want to spend time on duplicate testimony for the court.
Okay. Where is the child today?
He's at home with Miss Pearson. He stayed home from the YMCA today.
Okay. Anybody else have a witness that you absolutely need to call?
No, Your Honor.
Okay. All right, let's go ahead and start with closing, Mr. McKeska.
Thank you, Judge. Judge, the department is asking that the court authorize the change in placement for Christian Pearson today. The only evidence that's been presented today in court is uncontroverted. Ms. Pearson is not meeting Christian's physical and emotional needs. She's exposed him to individuals that he's made outcry statements about of harming him and of cussing him out while Ms. Pearson's been present. And she didn't take any sort of measures to be proactive or to be protective. Mr. Cooper has extensive criminal history, including domestic violence. He has extensive CPS history, including RTBs for physical abuse of children. And even if Ms. Pearson's not prohibited from spending time around Mr. Cooper, she's certainly demonstrating that she has learned absolutely nothing from her services during the course of the previous case and the course of this case by voluntarily spending time with an individual that has that sort of history. And her decision-making capabilities and her protective capabilities are certainly questioned when she's allowing this individual to have access to her child. Ms. Pearson withdrew Christian from his MHDD services. He was not discharged. If her statement of him no longer needing counseling services were true, then Christian wouldn't be enrolled in counseling services with K-Star. Christian absolutely needs these supportive services. The court has seen that over the course of the previous case and this case. The court previously ordered that Christian be able to complete or that we complete an IDD evaluation on Christian. And MHDD is the service provider to do that. And she withdrew him from those services, preventing us from being able to get the needed services for him. And then finally, Ms. Pearson's been sporadic in her engagement in services. She's on her third individual counselor during the course of this case. She's not going to be able to make any sort of therapeutic progress when she's constantly changing counselors. You have to redo the intake. She has to reestablish a connection with her therapist, then start getting into the issues. And because of her lack of continued engagement with the same therapist and being continually discharged from those services for non-compliance really does set us back in being able to move towards a final resolution in this case. And finally, Ms. Pearson's behavior in front of Christian when Mr. Tucci made her unannounced visit earlier this week. Ms. Pearson directed questions directly to Christian, asking him if he wanted to be placed in a foster home. Even if, Mr. Tucci brought up the issue and they were discussing something that escalated to the point of it becoming aggressive towards one another. The fact that she directed a question like that towards her 10-year-old child is highly inappropriate. And again, shows that Ms. Pearson has learned absolutely nothing through the course of this case. So we are asking that the court authorize the change in placement today, that we are asking the court to find that she's not meeting Christian's needs. And we're asking the court to enter orders today that are in Christian's best interest. Thank you.
Ms. Halrung, you're aligned with the department, correct?
I am, Your Honor.
Do you have anything specific that you want to add to Mr. McKeska's argument?
Your Honor, my biggest concern for Christian is what Ms. Harding detailed. The reason that I asked for the hearing on June 7th is because there has been a marked change in his demeanor and how he interacts with people. He was very engaged in school and very engaged in YMCA at times, but since he has been with Ms. Pearson, he's a different child. He's withdrawn, he's sick all the time. Your Honor, I think his welfare is definitely in jeopardy at this point, and I would concur with Mr. McKeska's request.
Thank you. Mr. Rudkin or Ms. Harris, anything you want to weigh in on here?
No, Your Honor.
Yes, Your Honor. My client has consistently maintained that he thinks the best place for his child is with Ms. Pearson. We've heard a lot of evidence today about what Ms. Pearson supposedly hasn't been doing or how she hasn't been meeting his needs, but we have not heard any testimony about what Belong or CASA have done other than observe since the last hearing to improve the situation. So they're placing all the burden on Ms. Pearson without meeting their obligations to try and meet this child's needs. I think that instead of a removal, that the department and Ms. Pearson should be required to have a meeting, work together, set out a very clear timeline, and figure out what the other parties are able to do to help Ms. Pearson through this process.
Thank you. Before I
Your Honor, am I able
just yes, Ms. Acosta, I'm going to give you the opportunity. Anything else that you want to add on behalf of Costa, either Mr. Nelson or Ms. Harding?
No, Your Honor.
Okay. All right, Ms. Acosta.
Judge, the basis for a removal of a child is supposed to be immediate danger. Under the statute, when a child is taken into possession, the department is supposed to be able to prove that there's an immediate danger to the physical health or safety of the child. And I don't think that they've done that here. I think that they've shown that there are some things that need to be worked on by both the department and by the mom, but I don't believe that they've shown that Christian is in immediate danger. Some of the things that were brought up with the mother, missing appointments, they themselves have admitted that Christian has been sick a lot since he's been with the mother. I don't think that needs to fall directly on the mother. Kids get sick, and sometimes they get sick in different timeframes. So to say, oh, well, he's with mom now and he keeps getting sick, and to put that on mom, I don't think is reasonable. The department is, to my knowledge, is still the managing conservator. That's why we're here. And so I would say it's on them as well to ensure that he's remaining healthy and getting treatment. We did have a meeting. We did go over things that needed to be addressed. And I would agree with Ms. Harris. I think that everyone needs to continue working to ensure that Christian can maintain his residence with Ms. Pearson. Thank you.
Your Honor, may I just quickly respond to the assessment that immediate danger is what the standard is here, Your Honor?
You may.
This is not a 262, Your Honor. This is, the department already has custody of the child. This is a monitored return. This child was placed with Ms. Pearson with the understanding she would follow the safety plan. She has not. And she has endangered this child. The standard that the court should be using, and my argument would be, is whether there's a continuing danger to the physical health or safety of the child, and whether removing the child would be in the best interest. The reverse standard of what it would be for 263.002C. Thank you.
All right, Mr. McKeska, any rebuttal?
Ms. Elrond took the words right out of my mouth, Judge.
All right. Ms. Pearson, who is in the room with you?
Christian and myself.
Did you say you're just there yourself?
Christian is here and myself.
Okay, so Christian's listened to this whole hearing?
Yes, sir.
Okay. Based on the arguments, evidence of counsel, the court will find that it has all parties entitled to citation and notice were duly cited and served in this motion as of June the 26th. Mr. McKeska, court takes judicial notice, and Mr. McKeska screen shared the notice that all parties were served with timely notice of the motion. We're in an extension, as Mr. McKeska stated, and as Mr. Duce testified to. And a lot of time, not only on the court's docket, but a lot of all of the parties' time has been invested in what was best for all of the children that were in this case when we started. And most recently, we put a lot of time, both on the docket and off the docket, into making sure Christian's needs were met. And what I've heard this morning is that there's from more than one witness, there's a definite change in the circumstances. I don't think there's any denying that. I don't think anybody can deny that. And Ms. Harris and Ms. Acosta both made the argument that there hasn't been enough evidence as to what the department has done or what CASA have done. But we're in an extension, and the court placed this child back at home because the mother's position was that she has done enough to get the right to make these decisions for her child without supervision after a lot of time has been spent and a lot of effort has been spent to get her to that point. And it's the court's interpretation of what's been presented here today and what's been presented in previous hearings, and my knowledge of this case is that she's not demonstrating that. She's not making a demonstration at this point in time that she is meeting the child's physical health or mental needs. There's no dispute as to what's been missed. There might be a dispute as to why, but at this point in an extension, we shouldn't be here. I have given Ms. Pearson every opportunity that I could as the judge presiding over this case to be reunified with her child. And we've placed the child back at home and things are not going well. This is not a healthy situation at this time. So I'm going to grant the department's motion to change placement today. So Ms. Pearson, you stay right there. Christian stays right there with you. And Ms. Artuche, Mr. McKeska, figure out what we need to do to change placement. Now, that being said, and that being the court's order, am I finding that his mental and physical needs are not being met at this time? This case is going to continue. The case is not over. He's just going to live somewhere else right now because I want to see that his mental and physical needs are being met. And then we'll figure out what the next step in this process is. So that'll be the order of the court department to prepare the order, and the move is to take place today. I'm very concerned about some of the things I've heard this morning and some of the people, specifically one person that Christian has been exposed to. And to know that he's going from this child who was invested in things and wanting to do stuff and being involved and opening up to a guarded, sickly, sleeping, tired child who doesn't want to do anything, it says a lot to me. Mr. McKeska, is there anything I failed to address?
No, Your Honor, we'll make arrangements to pick him up from the Flagstaff today.
All right, and we'll be back for the next permanency review, August the 2nd, 2023 at 9 a.m. Thank you all for your time and your service. If nothing further,